Delta 8 THC, the tetrahydrocannabinol isomer burning up the carts and charts. It's popular in vape carts and edibles, but is D8 legal? It seems like a perfect episode for... Hello, my name is Tom. You can find me on Twitter. It's my little @ right there, Tom at Weed Law. You can also email me at my law firm, Tom at Collateral Base, or go ahead and hit up Google and Google Cannabis Lawyer, and you can find my blog where I'm going to house this piece on if Delta 8 is legal later at cannabisindustrylawyer.com. So let's kind of dive into it right now. On August 21st, 2020, the DEA published this rule and made it effective. And so this rule clarifies, and by that I mean it's what they call an interpretive rule. So it's effective immediately. What it means to be compliant with the Schedule 1 substance, that is marijuana, and then the unscheduled substance, which is hemp. And it provided some guidance, some questions. As I reviewed the literature that was out there and spoke with other counselors, I began to agree with how Harris and Bricken, and shout out to them, and also the National Hemp Association, shout out to them as well, interpreted the DEA's laws. So we could say that it kind of muddied the water, and we're not going to necessarily talk about all the extracts. We're going to talk about a few of them. Principally, we're going to be talking about Delta 8 THC, also called D8, which I am recommending that we start referring to as D8 hemp derivative, because the 2018 Farm Bill is extremely vast in its definition of hemp. Hemp is all parts of the cannabis plant, whether growing or not, plus all cannabinoids, all derivatives, all extracts, all isomers, acids, salts, on a dry weight basis of not more than 0.3 Delta 9 THC. One thing that the National Hemp Association points out in their analysis of the new DEA IFR, which of course is interim final rule, is that they didn't really mention decarboxylation, which is great. They did really only mention the line of Delta 9 THC, not even Delta 8 hemp derivative or Delta 8 hemp, D8 hemp. All of those are more lawful than synthetic Delta 8 THC. What is Delta 8 THC? You see, Delta 8 THC is an isomer of Delta 9 THC because these two compounds with the same formula but different arrangement of atoms in the molecule at different properties. Delta 8 is derived from CBD hemp extracts that creates this new isomer, this new cannabinoid, after the hemp plant is grown. And again, remember, the 2018 Farm Bill defined hemp very broadly. All derivatives, extracts, cannabinoids, isomers, acids, salts of isomers, whether growing or not, with Delta 9 THC levels of not more than 0.3% on a dry weight basis. The DEA was very clear. They didn't actually mention Delta 8 hemp in their rule that came out on August 21st, 2020 at all, to be honest. But they did note that the 2018 Farm Bill modified the definition of marijuana so that it takes out the definition of hemp. So hemp, which is all parts of the plant, cannabis, sativa, and all derivatives, extracts, cannabinoids, isomers, acid salts, provided that it does not have a Delta 9 THC level of more than 0.3% on a dry weight basis. The reason why some people are concerned that the new rule may spell doom for the fledgling D8 industry is that it has to do with what is synthetic. What is a synthetic? And so we're going to argue that synthetic cannabinoids are like HU-210. And so now the changes to the definition of tetrahydrocannabinols, that's something interesting. Tetrahydrocannabinols, except for tetrahydrocannabinols in hemp as defined under Section 1639 of Title VII, which of course is the Farm Bill and its definition of hemp. Now, the definition of hemp includes all cannabinoids, including all tetrahydrocannabinols, which D8 THC would be one of them. The ones that they are looking for, the line in the sand is that 0.3% or more, D9. So for tetrahydrocannabinols that are naturally occurring constituents of the plant material, cannabis sativa L, any material that contains 0.3% or less of dry weight basis is not controlled unless specifically controlled elsewhere under the CSA. And then the DEA goes on. Conversely, for tetrahydrocannabinols that are naturally occurring constituents of cannabis sativa, any such material that contains greater than 0.3 of dry weight remains Schedule 1. And then it goes on and it gets a little goofy, where this is what's causing some fear. When it says the AIA does not impact controlled status of synthetically derived tetrahydrocannabinols for controlled substance number 7370, because the statutory definition of hemp is limited to materials that are derived from the cannabis plant. For synthetically derived tetrahydrocannabinols, the concentration of D9 is not the determining factor. All synthetically derived tetrahydrocannabinols remain Schedule 1 controlled substances. What does that mean? Well, to me, that means that D8 hemp should be marketed that way, as you are taking hemp, you're extracting it into a CBD, and then you are deriving a cannabinoid, a tetrahydrocannabinoid, out of it. And because of that, it is still hemp. There is a distinction without a difference, really, because a synthetic is different than a derivative. We have hemp, we have the hemp extract, and then we have a derivative of the hemp extracts. And derivative, just like synthetic, these are not terms that are defined at law. They are not terms of art. Now that's important, because then what's going to happen is when we're reviewing the statute, the Farm Bill, and the other corresponding statutes regarding synthetic cannabinoids, and especially synthetic THCs, we are going to need to look at how the words actually mean we're going to have to look at what the words actually mean in the plain meaning, the English language. So we're going to have to look at various sources for this. We should look at chemistry dictionaries, because a derivative is a chemistry term. We might also want to look at Black's Law Dictionary, because Black's Law Dictionary historically has been where, and I'll guarantee this, the U.S. Supreme Court and the Illinois Supreme Court, any state Supreme Court, has probably cited to Black's Law's Dictionary before, when a specific statute does not create a term of art and define what something is. Just like the Controlled Substances Act, if you go to its definitional sections, you're going to miss a few definitions. First off, the word derived isn't there, nor is synthetic, nor is extraction. So we'll go back to what the chemists say about a derivative. In chemistry, a derivative is a compound that is derived from a similar compound by a chemical reaction. Now, who says that? Well, chemists do. All right, now let's go to what do lawyers say that a derivative is, and we'll turn to Black's Law Dictionary. Black's Law Dictionary defines derivative as coming from another, taken from something preceding, secondary, that which has not its origin in itself, but owes its existence to something foregoing. How do we make DH hemp? How do we make D8 hemp derivative? Well, we start with some CBD extract, and then we do a chemical process, a chemical reaction, and then you have Delta 8 hemp, Delta 8 THC hemp. And you spin out any non-compliant D9, and then you get your D8 carts, or you get your D8 isolate that you can then use in your edible products. So let's see. Under these definitions of derivative, under both chemistry dictionaries and Black's Law dictionaries, would D8 hemp qualify under the 2018 Farm Bill's definition of hemp? I think it has to. I mean, does the hemp, the D8 hemp, become that by a chemical reaction of something preceding it? Yes, it is a derivative. They take the CBD and they make it from that. So that's kind of how chemists understand a derivative to me. And it's the same thing with lawyers. Something that is secondary, that which not has its origin in itself, but owes its existence to something foregoing. Like we said, you pick the hemp, you test the hemp, you throw the hemp in the extractor. That's where you cut into the real problem with the DEA's rule, by the way. And then during the extraction and the derivative, actually they don't call it derivative, they call it derivative or derivation process. that is when you take hemp and you turn it into a different cannabinoid, a different isomer called D8 THC. I'd recommend calling it D8 hemp to avoid the confusion, because you could have D8 THC still be illegal if it's not derived from hemp. What do I mean by that? Well, now again, there are actual synthetic cannabinoids out there, and they're all Schedule 1. And many of these synthetic cannabinoids were made at Hebrew University with Dr. Michelin. And therefore, they're going to have HU dash numbers, okay? So HU dash 210 is a synthetic cannabinoid. Sometimes it may have been used in spice, for example. I'm not sure if you're familiar with spice. It was synthetic cannabinoids sprayed on potpourri and whatnot. Now, in 1988, when Dr. Michelin at Hebrew University invented HU 210, he took myrotenol, nope, I'm mispronouncing that, MYRTENOL, myrotenol, and 1,1-dimethyl resveratrol, and acid catalyzed it to get HU 210. Myrotenol, I put it down there on the bottom so that you can struggle over the word as well, and 1,1-dimethyl resveratrol, and then acid catalyzed them to get the HU 210. That is a synthetic cannabinoid. Taking hemp, extracting the CBD, and deriving delta 8, a different isomer, a different cannabinoid, even a different tetrahydrocannabinol. Those are all, from my plain reading of the Farm Bill, and the words that are defined and the words that aren't defined, still lawful hemp derivative. It might not be lawful at the state level. However, that creates a supremacy clause argument, because the USDA really does not want to impede the interstate commerce in this hemp. They're trying to help this hemp industry. That's the point of why the definition under the 2018 Farm Bill for hemp is so large, because it is supposed to be all the plant except for the Delta 9, for a specific level of the Delta 9. And right now, we're going to go over a couple of the things that I believe adequately reflects that explanation. And so one of them is, of course, you can go to the National Hemp Associations. Shout out to the National Hemp Associations. A piece that they put out regarding the IFR's words from the DEA, trying to interpret the 2018 Farm Bill. And so it's pretty nice. You know, what does it mean? Should the industry be concerned? The short answer is no. And then one of the nice things that the National Hemp Association said was it did not mention the word decarboxylate anywhere. So it appears to be maybe giving the industry a little bit of breathing room, because they're only zeroing in on the D9 THC aspect of it, which is nice. And so while total THC remains the protocol for determining compliant hemp at the USDA farm level, the DEA IFR only references D9. So hopefully that's giving some much needed space for the smokable hemp market, which is important, because those USDA rules have actually kind of been postponed for another year. And it looks like now we're going to have crop years out through 2021 in order in which to get ahead of the genetics or regulatory reform. The Farm Bill had a different definition than the 2014 Farm Bill. The 2022 Farm Bill hopefully has hemp defined as the plant, but raises it to 1% total THC. And then doesn't say by dry weight basis, says at its finished product or something like that, so that we don't have this confusion. And then this was correct. Like, I totally agreed with the National Hemp Association on this. The issue of D8 THC was not addressed at all in this document. And so some people are going to say that's a go ahead. There is another argument made that D8 might fall under the category of synthesized THCs and remain a Schedule I substance. I think that violates the plain meaning of the word derivative and all and cannabinoids and isomers. That is what the definition of hemp is. The real problem, and then this is Harrison Brickens and Daniel Short wrote this one. Shout out to Harrison Bricken. They did a great job, in my opinion, on the analysis, and I agreed with a lot of it. And so here's the dangerous part of the DEA's rule. And so they don't care when the extraction is going on. Any such material that contains greater than 0.3% of D9 on a dry weight basis remains a controlled substance. Now, that's terrible. That's terrible in the sense that you can pick your hemp and it'll test. Nice. And then you throw it into the extractor. And what happens? You yank out all the cellulose. You yank out all the water. You yank out all the waxes. You leave the terps. You leave the cannabinoids. And your delta 9 levels go over 0.3. They do. But then by the time the product leaves the factory, you have brought them back down. And so the fact that there might be this springing liability out there for the industry is, to be honest, ridiculous. And that's why you have to go to regulations.gov and then give us a like, give us a subscribe. I am now going to share with you our comment that if you want to join this comment, the way to do that, we're going to make another one of these videos on the comment where I'll read the comment. I'll put the comment into the description section. You can just copy it and paste it and click over to the Department of Regulations, I guess. It's just regulations.gov. They're making a new beta page right now. And then you'll be able to very quickly upload that and join your comment into ours regarding Delta 8's okay. And by the way, you can't enforce the law in such a way that it creates a cataclysmic risk to the processors that have invested all this money and that believed what they were doing was lawful. And now you're telling me when you harvest the hemp, shuck it, buck it, and throw it into the extractor, boom, you're a marijuana dealer? No way. So give us those likes, give us some subscribes, tune in on Wednesdays and Sundays. If you have any questions, leave them in the comments or go to cannabisindustrylawyer.com and ask questions there, and that might become new content.